The arrested opposition lawbreakers may not get bail because they threaten the security of the witnesses. Because some people have been saying, you give these people bail, give them bail. Yes, but because they are not Democrats, when we release them, they attack the witnesses. You cannot have democracy without people with the spirit of democracy.
While speaking to UBC in the Knowing Your Law segment, Walubiri argues that claims that an accused person will interfere with investigations pending trial are largely speculative.
The idea that accused persons would interfere with investigations is again speculative.
He says the prosecution bears the burden of proving with credible evidence that such interference is likely. He reveals that otherwise, innocent people could be detained on mere allegations undermining the purpose of the bail system.
They are merely suspects. Otherwise, if anybody accused of a serious offense doesn't have bail, then the system will be abused. If you want to take my land, you accuse me of murder or terrorism, and I remain on remand for 10 years, and you take my land or my wife or my property. So that's not a sound reason. That is why the person has a right to apply to a court of law to be released on bail. But you see, even where investigations are not complete, the burden would be on the prosecution to show how an ordinary citizen would interfere with the police officers and other investigators.
Peter Walubiri maintains that all offences, including capital in nature, are bailable.
It's not even about the gravity of the offense.
He says that witness protection is a state obligation and should not be shifted onto suspects by denying them bail. Instead, courts should primarily consider whether an accused person is likely to abscond and fail to appear for trial.
And the main factor to take into account is, will the accused person, if released on bail, turn up for his trial? The state has all the means to secure witnesses. That's why we pay taxes.
Walubiri adds that Article 23 of the 1995 Constitution was crafted to uphold the presumption of innocence, ensuring that no person is punished before being convicted by a competent court. He further argues that respecting judicial independence and allowing courts to exercise their constitutional discretion when determining bail applications should be a collective responsibility.
Judges are not ordinary people. They weigh the gravity of the offense or the circumstances, and they should be trusted to use their discretion to grant bail judiciously. In my experience, I don't see many instances where judges have granted bail recklessly, but increasingly they are being pressured not to grant bail.
Crispus Arinitwe reporting for UBC.